Hey, welcome back. Grab a coffee because today's story does not need a slow lead in. It just needs you sitting down before I tell you what the United States government did to itself this week. There's a specific kind of embarrassment that only happens when an institution contradicts itself in public, on the record, within about 24 hours. And today, the Justice Department and the President of the United States managed to disagree with each other about a hole in the ground. Not metaphorically, an actual hole filled with actual water, on the National Mall, 450 feet from the Lincoln Memorial. And somehow this small, damp, structural argument tells you almost everything about how power is currently operating in Washington. So, let's get into it. Back in the spring, ahead of the country's 250th birthday celebrations on July 4th, the Trump administration fast-tracked a $14 million facelift of the Lincoln Memorial reflecting pool. New liner, new coating, a shiny centerpiece for the cameras. It did not stay shiny. Within weeks, the water turned green, the coating started peeling off in sheets, and the pool that was supposed to be a monument to American greatness started looking like something you drain at a motel that's about to lose its health inspection. Naturally, someone had to be blamed, and naturally, it was not going to be the renovation itself. In late June, U.S. Attorney Jeanine Pirro stood in front of cameras and announced that a former Olympic canoeist named David Hearn had, in her words, forcefully and violently ripped up the pool's lining with his bare hands. He was arrested, charged with felony destruction of property, a charge carrying up to 10 years in prison, all resting on the idea that he'd caused more than $1,000 in damage. President Trump, for his part, had already been narrating this as an act of vandalism for weeks, describing gashes that grew from 250 feet in June to 300 yards by July, which is either a remarkably fast-healing memory or a remarkably fast-growing crime scene, and I will let you decide which. Then, last Friday, something happened that almost never happens. The Justice Department filed a motion asking a judge to drop the entire case, admitting in 20 pages of court paperwork that the damage was, in their own language, the result of a hasty and botched installation by the contractor, not vandalism, not Hearn, not anyone with a grudge and a pocket knife. Buried in that filing was an email from a National Park Service engineer, dated June 11th, warning colleagues at the Interior Department that the coating along the pool's edge was already showing signs of peeling and was, quote, vulnerable to further damage. That email exists more than a week before Hearn ever set foot near that pool, which means the government's own internal paper trail shows the crime scene was falling apart before their suspect arrived. Hearn's attorney, Norm Eisen, summarized the whole operation in 3 words: ready, fire, aim, which is, I think, the most accurate description of modern prosecutorial strategy I've heard all year. And I say that as someone who watches a genuinely alarming amount of prosecutorial strategy. Now, you would think, naively of course, that when your own Justice Department produces a 20-page legal filing walking back a felony indictment, citing your own agency's engineers, that would be the end of it. It was not the end of it. On Saturday, President Trump posted on Truth Social that he disagreed, and I'm going to read this part directly, because paraphrasing would honestly undersell it. He wrote that he disagreed 100% with his own U.S. attorney, that he didn't know what she was thinking, and that to him, it was a pure case of vandalism. He then cited, as supporting evidence, a photo of graffiti reading 8647 scratched into the grass nearby, grass notably not the pool, and allowed that there may have been, quote, some contractor difficulty, but insisted the major damage was still caused by vandals. So, just to be clear about where we've landed, the President's own Justice Department, after reviewing internal engineering documents, formally told a federal judge there wasn't enough evidence to prove vandalism beyond a reasonable doubt. And the President responded by rejecting that conclusion in a social media post, using a photo of unrelated graffiti on the lawn as his rebuttal. That is not a disagreement about facts. That is 2 branches of the same administration standing in the same building, looking at the same pool, and describing 2 different crimes. The Interior Secretary, for what it's worth, backed the President's version within hours, insisting the evidence was clear that vandals were responsible, which is a bold thing to say about evidence your own department helped produce for the filing that says the opposite, but here we are. Now, Why does any of this matter beyond the mildly farcical spectacle of a government fighting about a puddle? It matters because of what it costs, and I don't just mean the $14 million, though we should sit with that number for a second. $14 million for a landmark renovation that failed within a month and needed pumps running behind it, at a site chosen specifically because it was supposed to be the visual symbol of the country's 250th anniversary. It matters because a man was arrested, indicted by a grand jury, and facing a decade in prison based on a theory that his own government's engineers had already quietly disproven weeks earlier, and nobody checked before they held a press conference about it. And it matters because when the head of the executive branch publicly overrules his own prosecutor's sworn factual findings, using an unrelated photo of grass graffiti as his evidence, you are watching, in real time, what happens to institutional credibility when the story matters more than the paperwork. There are still 3 other people out there facing lesser misdemeanor charges tied to this same pool, each of them now watching a president publicly reject the very findings that got the marquee felony case thrown out. I don't know what happens to their cases. Genuinely, I don't. That's not a rhetorical hedge. I think even the prosecutors currently working this file don't know, because the official position appears to depend on which floor of the building you're standing on. What I do know is this: institutions survive being wrong. They survive scandals. They survive the bad press. They even survive $14 million puddles. What's harder to survive is a pattern where being wrong in public gets rewarded, and being right in public, even when the right answer comes from your own side, gets overruled by Truth Social. Because the next contractor cutting corners on a rushed government project, and the next low-level prosecutor deciding whether to charge someone before all the facts are in, are both watching this exact case, drawing their own conclusions about what the incentives actually are here. So here's where the water actually ended up settling. The pool that was supposed to be the shining, camera-ready symbol of America's 250th birthday is currently sitting behind maintenance barriers with pumps running. A formerly accused felon has his life back. 3 misdemeanor defendants have no idea what happens next. And the President of the United States has now publicly and specifically disagreed with his own Justice Department's sworn legal conclusion, using a photograph of grass as his closing argument. I am Marcus Fenn. This is Borderlines. And if there's a lesson in all $14 million of it, it's that some administrations build monuments to greatness, and some just build very expensive metaphors.